My Lords, coming on to relevant features of the factual and procedural background. As your Lordships know, the disputed amendments all concern claims for financial losses consequent on the opening of the criminal investigation in April 2013, and they were pursued in relation to the 2017 and 2019 actions. The categories of amendments are set out in paragraph 25 of our skeleton, which is page 7 internally and page 48 of core bundle. Were borrowing costs amendments, adding claims that the investigation caused borrowing costs of subsidiaries to increase, and those increased costs caused the value of ENRC's shareholdings, of course indirect shareholdings in the subsidiaries, to diminish commensurately. Secondly, fees amendments, adding claims that the investigation caused subsidiaries to incur legal and other fees, and that those then caused the value of shareholdings to diminish commensurately. And then interest amendments, adding claims for interest as damages on the basis that ENRC subsidiaries had to borrow to fund expenditures, including increased borrowing costs, and that these interest costs caused the value of ENRC's shareholdings to diminish commensurately. So all three categories depend upon the DSV basis, as it's been put, and my learned friends' dollar for dollar contention. Although our opposition to these amendments is based on lateness, lack of justification for delay and evidential prejudice, I stress, of course, that we dispute them on their factual and legal merits, and nothing I say should be taken as accepting that they have substantive merit. In order to see how the case was originally pleaded, may we go briefly to the re-amended particulars of claim in the 2019 proceedings, which is at Core Bundle tab 13, page 296. And this is the form of pleading which was put before Mr Justice Waksman on the 15th of January, and it therefore shows the amendments, but we can see the original text. Paragraph 1 pleads clearly that the claimant is Eurasian Natural Resources Corporation Limited, the parent company of the group, and that the term ENRC is then defined thereafter as that company and that company only. Then if we go to the relevant pleas of loss, they begin at page 369 on paragraph 54, where it is pleaded that the SFO's conduct has caused ENRC, and only referring to ENRC, to incur the following categories of loss and damage. Paragraphs 55 and 56 pleads claims for fees and expenses paid by ENRC. And in each case, your Lordships will see at the bottom of the paragraph, a sentence has been added that some of these were in fact paid by other ENRC entities, and ENRC is claiming loss in the form of diminution in shareholding value. And the pleaders have sought to limit the apparent extent of the amendments by referencing paragraph 31 of the phase 2 further information, which pleads out the DSV basis of the claim, as we'll see in a moment. Then page 371, paragraph 59, consequential losses. In its original form, it pleads that the ongoing criminal investigation damaged ENRC's reputation and resulted in further losses in ENRC's failure or loss of a chance to borrow funds from, or on more advantageous terms from, lenders who have declined to deal with ENRC. So the pleading is that the reputation of ENRC, nobody else has been damaged, and that ENRC, nobody else, has lost the chance to borrow funds on better terms. And then the amendments seek to add reference to the subsidiaries, again referencing the further information for the DSV basis of the claim. And then finally, paragraph 60 pleads out the claim for interest as damages, that ENRC borrowed on commercial terms, money spent on unnecessary legal and other fees, and that ENRC paid interest of at least, was originally pleaded at 6.1% per annum. So again, the original case is plain that the borrowing was by ENRC only, and the amendment sought to expand that to the subsidiaries. Now, the SFO has made clear in its evidence that it always understood ENRC's claims only related to borrowing costs ENRC had incurred and expenses ENRC had been obliged to pay. The SFO didn't understand the claims to relate to borrowing costs of subsidiaries or to expenses incurred only by subsidiaries. The SFO didn't understand any claims to be made for diminution in shareholding value in relation to ENRC's holdings in share capital of subsidiaries. And for my Lord's note, that's paragraphs 39 and 44 to 47 of Mr Whitfield's fourth statement, tab 24, pages 228 to 229 of the supplementary bundle. I don't think you need to turn it up because there's no dispute about it now. But that was the state of the SFO's knowledge, and it's relevant because initially in the application it was suggested that the SFO must have somehow guessed that the claim might relate to the subsidiaries' borrowing costs and other expenses. What then happened was that there was an RFI and some following correspondence, and these developments are relevant because they form the background to the exercise of the judicial discretion, which shows that we were trying to explore the limits of the universe of documents and ensure that document holds were placed in early 2020. For these documents, my Lord, I need the supplementary bundle, first of all at tab 4. This was our RFI application, which at the bottom of paragraph 20 set out, summarised requests that had been made in relation to the original version of paragraph 59 of the particular claim, seeking details of the third parties with whom relationships are alleged to have been affected, and any specific business transactions relied upon on the basis that they must have been known to the pleaders. Hogan Lovells answered that application in a letter we see under the next tab, tab 5, page 23. We see from the heading on the first page that the defined term ENRC is used as in the pleading to refer to the claimant company, not any broader group. And at paragraph 24 at the bottom of the page, Hogan Lovells address request 173 to 176, which had been covered in the application. And they give their response over the page. First of all, at paragraph 3.2, they repeat a proposal to have consequential loss addressed at a second stage trial. Then at paragraph 3.3, they give some answers, again repeatedly referring to ENRC as the entity entering into borrowing transactions. So, third line, ENRC at all material times relied on lending from large financial institutions. Sixth line down, ENRC's diminished ability to raise funds. And then at B, the average interest rate that ENRC paid. And then over the page at 26, paragraph 3.4, Hogan Lovells suggested that quantification of these borrowing costs would be matter for expert evidence. And it was not appropriate to provide more information now. Now, because a request for information on specific transactions was answered with this statement that the quantification of these losses would be a matter for expert evidence, Evershares inferred that ENRC would be relying upon generic factors such as those specifically identified at 3.3a to c, rather than upon specific transactions. And as a result, they sought to pin the point down on page in their following letter, which is under the next tab, page 27, letter of the 13th of January 2020. And in a series of numbered points, they said, first of all, that paragraph 59 referred to lenders who had declined to deal with ENRC. Paragraph 59 of the particulars of claim referred to lenders who had declined to deal with ENRC or demanded increased interest. But the impression, therefore, was that the pleaders had in mind specific lending transactions. But 3, it's apparent from the letter that ENRC was instead basing its claim upon generic considerations rather than specific lending transactions. And then at page 28, they said this: if, contrary to our understanding, the ENRC will seek to rely on specific transactions, specific third parties or specific lenders as forming part of its consequential losses, then it's essential that these are identified now so as to enable the SFO to investigate these allegations. This is particularly important in circumstances where this claim relates, as it does, to events between 2011 and 2013, and where ENRC is proposing that assessment of damages, if needed, be delayed to a second trial. There's a real risk that the relevant counterparties, third parties and lenders will cease to maintain their records, or that their employees will move on, hindering the SFO from investigating ENRC's claims. To complete the sequence, the correspondence ended there, but there was an amended response to RFI, which we find under the next tab. Page 31, paragraph 173 and 175. ENRC explained that it did not seek to claim losses arising from failure or loss of chance to enter into specific transactions, but at the end of the paragraph reserved the right in expert evidence to rely upon specific business transactions, etc. Now, in our submission, it's plain from that sequence of correspondence that we were concerned to ensure that documents were preserved which could be relevant to these claims. If the ENRC had pleaded its case as now presented in the amendments, the SFO would have pressed for a litigation hold to be put on the document repositories of the relevant subsidiaries.
I think that's in dispute here, is it? I think.
Well, it's what Mr Whitfield says in his witness statement he would have done. That's paragraph 51. And it is, in my submission, borne out by the correspondence we've addressed. So the background...
I think all the argument is on the assumption that if the claim had been prefaced sooner, you would have requested a litigation hold on documents.
Yes, but the background to the judge's exercise of discretion, which, as we'll say, we'll submit is a multifactorial one, is that this is a subject which we had been specifically addressing in early 2020. We had shown our determination to obtain proper document holds over material relevant to specific transactions which might be relied upon. And it's therefore in that context that ENRC later comes to court and asks to amend to advance different claims in circumstances where years have passed, another 5 years have passed.
But if a party says, we really now want to know what your case is, please set it out, and we're then going to ask you to preserve documents, you can't then say that gives you some sort of super added ground for opposing an amendment. It doesn't mean that it has to be looked at on a different basis or different factors applied.
Well, we say that it is part of.
Any more than the judge indicating at a CMC back in 2020 that you should advance any amendments that are lurking out there. We have to look at the amendment application that was made in 2024 on its merits, taking into account that whenever amendments are made, they necessarily will not have been made sooner.
Well, not all amendments could have been made sooner. Sometimes an amendment is made as a result of disclosure or an evidential development which a party was unaware of.
This amendment was made right at the start of the quantum hearing, going to an issue of quantum.
Well, in our submission,
quantum hearing, I mean the quantum phase of the trial. It was made before well before the first CMC, and you can certainly make the point that it could have been made earlier and that you have been pressing for details, but it wasn't. The question of whether it was late is a think you'd accept a relative one. And this wasn't very late, was it?
Well, we will say that it was very late, because lateness is a relative
Well,
question.
the judge didn't find it was very late, and you haven't put in a respondent's notice arguing that he was wrong in that.
The judge found that it was late, and he was right.
He didn't say it was very late.
He didn't say it was
very
late, because that's a term which has become a term of art, meaning an amendment which puts at risk the trial date.
But you just said now, you said that you contended it was very late.
And I'm sorry, it was seriously late. It was delayed by 5 years. That is significantly late. I'm sorry.
Well,
I'm sorry for using.
There's a difference between saying a claim could have been advanced 5 years ago and saying it's been delayed by 5 years if it is made perfectly well before the trial at which that issue will be determined. And however you put it, the fact of the matter is this issue can be sensibly dealt with at the quantum trial. And the only issue about it, the only point you've got in opposition to it, is that it's possible that some documents have been destroyed between 2019 and 2024, isn't it?
Well, first of all, it is a serious point that documents which would have been highly relevant, we say, could well have been very relevant, appear to have not, well, there appears to have been no effort to preserve them.
Well, you're going to say have been lost or destroyed, but we don't know that.
We, as I'll go on to show, we sought to discharge the argumentative burden of saying we will need these forms of documents from the subsidiaries, and we note that you haven't put a hold on them. That, in our submission, against the background of the material I've shown you, at least put in some sort of responsive evidential burden on ENRC to say, no, in fact, we have looked into the matter, here are our document preservation policies, or here is a statement from the person responsible for archiving at each of these main subsidiaries, and documents have not been lost as a result of the hold not being applied, either because the documents have in fact been preserved, which ENRC has never sought to suggest, or because the documents would have all been gone to the winds by 2019 or 2017 as far as the 2017 proceedings are concerned. Anyway, that's a short answer to my Lord's point. We will come to the sequence of events leading to the application. There is then, as your Lordship says, the significant CMC in May 2020, and we say that the issue would have been ventilated at that point if ENRC had said, well, we're not putting a hold on, we are relying upon a series of specific transactions, we're not putting document holds on those transactions because we don't think the documents are relevant. So there was a clear opportunity at that stage to raise our concerns in this regard and take steps to ensure that material was preserved. That opportunity was lost because the point was not pleaded as it has been. Then, and of course it was at that CMC that the judge made his point that any amendments needed to be provided promptly. My Lord has it in mind, for your Lordship's note, it's tab 11 of the supplementary bundle at page 46, paragraphs 137 and following.
But that was the formal direction, was it?
That was
an indication.
It was an indication, but lest it be said by ENRC, we only needed to have our pleadings in a satisfactory state for the immediate phases. The judge had been very clear that he expected the pleadings to be in good order going into
But forgive me, all he was talking about there is if there's anything you're thinking you might amend, he was asking for known unknowns, wasn't he? He wasn't asking for unknown unknowns. You can't bring forward something you haven't thought of and won't think of for another 4 years.
Well, he was perhaps encouraging ENRC to cast its eye over the pleading and realise that it had made what it now says is a catastrophic mistake. Because it is part of the context, as the judge rightly included. We then have the Phase 1 trial, May to September 21. The Phase 1A trial, March 2023, with a judgment in December 2023. And then we had a directions hearing in March 2024. And at that stage, the court did start making orders in relation to Phase 2. The orders can be found at tab 16 of the supplementary bundle. And at page 87, your lordships will see that the judge directed the provision of further information in relation to the claims. Now this is 8 or 9 months before the amendment application, and the judge is directing further information in relation to the claims as currently pleaded. So while it is right to say, Mundell, that a CMC was yet to happen in early 2025, the Phase 2 directions began at this stage, March 24. And as your lordships will see from paragraph 6, ENRC was ordered to file and serve further information as to losses it was claiming, details of consequential losses, and so on. And then at E, identifying ENRC's borrowings. So everyone was still working on the basis, for the purpose of those directions, that this was a claim relating to borrowings by ENRC. It then obtained 2 extensions for serving the Phase 2 further information, and then served that in August of last year. We find that at divider 17, page 90. And that, for the first time, gave notice of the case the ENRC now seeks to run. But of course, there weren't amendments to the main pleadings at that stage. The ENRC initially took the point, we don't need to amend the main pleadings, we can just put these in through the further information position it later rightly resolved from. Page 103, ENRC sets out the increased borrowing costs claim in relation to the 2019 proceedings. And it states that the criminal investigation, as paragraph 37, resulted in increased borrowing costs for ENRC and certain subsidiaries, were then identified over the page on paragraph 38 in the list my lord saw. And paragraph 40, it sets out the diminution in shareholding value basis of claim. Now, it is true that it's pleaded that the diminution is in an identical amount to the relevant proportion of any additional borrowing costs paid by the ENRC subsidiaries. But there's no pleaded contention that ENRC will abandon its claim entirely if a lower proportion or amount is established. Of course, Mr Pillow has now pinned himself to that position, and I'll explain later why we say that that doesn't improve his position. It in fact only heightens the need for the material with which we are concerned. It's also relevant just to look briefly at the table annexed to the further information, which is at page 145. Because what this table shows is that the shares in the trading subsidiaries, such as SSGPO and Caschrome, were genuinely marketable securities, and there are various instances of ENRC holding companies transferring holdings of shares outside the ENRC group. So my Lord will, for example, see that in relation to Caschrome at item 18 on page 147. Caschrome ceased to be an ENRC subsidiary in 2018 when NV transferred its shareholding to another entity. Now, in our responses to this pleading, we and Dechert took the position that this and the other disputed claims were outside the scope of ENRC's pleaded case. And we did that in our reply at Divider 22, page 191, where we said that very limited disclosure had been provided, even known adverse documents hadn't been provided, and the NRC had sought to advance claims outside the scope of the pleaded claims, and we repeatedly made that point, for example, also at paragraph 30.1. We additionally contended that the criminal investigation hadn't been the cause, or certainly the entire cause, of damaged reputation and losses, including, for example, because the ratings agencies had started downgrading ENRC and its group before the criminal investigation, and because the ratings agency reports which followed the criminal investigation referred to a plethora of other reasons for the downgrades. I make that point because Lord Justice Males, in his permission to appeal decision, suggested that there was no dispute, but that the criminal investigation had been the cause of the downgrades. It was mentioned in some of the reports announcing the downgrades, but as one of very, very many other factors, including political risk, leverage, changes in corporate governance, and so on. I should also mention, in fairness to Mr. Millett, that he did plead a reflective loss point in his response, and also that we pleaded points of legal principle, including about the losses being outside scope of duty and too remote. ENRC, as I say, originally took the position that it could advance the claims without needing to amend. It later conceded that was wrong and made the application in November 2024. And our response to the application is in Mr. Whitfield's fourth statement, which is under Divider 24, at page 221. And from page 226, paragraph 24, we set out the investigation which would be required into the activities of ENRC's subsidiaries, including referring to aspects of our own Phase 2 further information response, paragraph 27, and then at paragraph 29, the need for investigation of a large amount of matters by the parties' experts to understand borrowing rates, how borrowing rates might have been impacted. So ENRC set out the types of documents which would be called for, and it exhibited, at the bottom of paragraph 29, a list of the categories of documents which would be required in relation to each subsidiary. So we say we fully took on and discharged the burden of raising categories of documents of the subsidiaries which could be highly relevant. And when I come to the relevance of the documents, I'll pin our submissions to categories of documents in our Section 1B DRD list. Paragraph 32, Mr. Whitfield refers to the fact that these lists of documents had not been dreamt up by lawyers, but had been provided by ENRC's experts. Sorry, the SFO's experts, my malaprop. Including, I should add, experts' views on what would be required to understand whether a dollar-for-dollar approach is a valid one. Which, as I'll submit, is not simply a matter of binary, legal, or expert analysis conducted in the absence of facts and documents. Now, after that statement had been served, ENRC in its evidence made no effort to say that litigation holds had not been, that litigation holds had been placed on any of the subsidiaries, nor to say that our points lacked merit because documents of the relevant subsidiaries would have been disposed of in any event. Those would, in my submission, have been a short and simple way to deal with the arguments which we had canvassed. In those circumstances, we say a very strong inference arises that the documents with which we are concerned were not the subject of a litigation hold, and that had the request been made for a litigation hold in, say, early 2020, then significant additional material may well have been available. Because if that weren't the case, ENRC, the only party who knows the answer, could have given that answer. Now, it is worth looking at... Is that a
finding the judge made?
Well, may I just, before we turn to the judgment, may we just look at how it was put in submissions, because in our submission it is relevant. The transcript is at page 301 under divider 30. And this was addressed internal page 55, page 314 of the supplementary bundle. That's the upper right quadrant, lines 23 and following. The fact the litigation hold has not been put in place doesn't mean that they, the documents, are not held or available. I simply don't know the answer to that question. And then further down, at page 56, line 16 and following, my lord shouldn't take from the fact that there has been no litigation hold the simple point Mr. Richards tries to make, which is that the document can't be produced. My point is that it might well be producible. It's simply not a proportionate exercise to look. Now, in our submission, the suggestion that it would have been disproportionate to consider whether a litigation hold would have made a difference in the context of the amendments and the values of the claims being advanced here, in my submission, does not stack up. The ENRC has chosen not to investigate this matter. It has decided instead to stake its colours at the hearing in January firmly and irreversibly to the mast that these forms of documents could not be relevant, and that everything of any potential relevance would necessarily be in the parent company's repositories. I'll identify in a few moments where it, or in a little while, where it made that submission. But in our submission, that was the argument with which the judge then had to grapple.
But the usual pattern on disclosure is that a party in your position says these are the documents we want, and it must be assumed that you've got them. That's the basis upon which you apply for disclosure. It can be assumed that you've got them. And it doesn't seem to me that it's the usual way is for you to say these are the documents which are disclosable, but we take it that they've been destroyed and wouldn't have been destroyed if there'd been a hold. Well, it seems to me it's putting it completely the obverse way to how it would normally arise. And the suggestion that a party applying to amend should adduce before the court evidence that it hasn't destroyed documents or evidence that if any were destroyed, they were destroyed before the claim could have been advanced earlier, seems to me to be quite a convoluted process where we're looking in the first instance at whether a prima facie claim is arguable and whether it can properly be tried at trial. And to oppose that on the ground and to say that you can oppose the amendment because they haven't said that they haven't destroyed documents or they destroyed them before they could have made the amendments. It doesn't seem to me that's the way it should work.
Well, as I say, well, it's worked out that way because of the approach taken by ENRC, which was to put forward these amendments while having put in a further information document saying that material had been lost since 2013. We then raise the point that subsidiaries documents are relevant, and we say that there is clear potential prejudice to be considered as part of the judge's multi-factor exercise of discretion, in that documents appear to have been lost and ENRC has not suggested that the documents of the subsidiaries can be supplied.
Forgive me, I think I really must pin this down. Where does the judge find that documents have been lost?
What the judge addresses in his judgment, and we'll look through it in a moment, what the judge finds in his judgment is that there is a meaningful risk of prejudice because, contrary to what ENRC has said, it cannot be presumed that documents of the subsidiaries are irrelevant, and ENRC has not sought to suggest that documents of the subsidiaries will be available. ENRC has chosen to fight its position by saying that documents of the subsidiaries could not be relevant.
Isn't the first question though on when you get to disclosure is you argue you have to identify what is relevant and disclosable, and then you look at whether or not those documents exist. I think what you're really saying is that even if ENRC contend that the documents which are relevant and disclosable are very limited, they nevertheless have to do a trawl to look for documents which they are contending aren't relevant or disclosable. I find that quite a difficult, again, not the usual way we deal with disclosure.
Well, this is a very unusual situation because of the way that it arose. But as I'll say in a moment, ENRC not only submitted to the court that the amendments should be dealt with before disclosure issues, but also that the court could legitimately rule on the amendments before turning to disclosure issues. Look at that in a moment. ENRC did not suggest to the judge that he could address the disclosure issues before he ruled upon the amendments. The disclosure requests we had made included a whole series of documents relating to the subsidiaries. And it may well be that the line that ENRC took of seeking to advance the amendments first was for good tactical reasons. Because if the disclosure had been considered first and we had got home on specific disclosure matters being relevant, then ENRC's whole basis for objecting to the risk of prejudice point would fall away. So they chose to fight the amendment on the basis that they did. And we'll look at the moment, it's pages 1 and 2 of the transcript.
The ENRC can suggest to the judge how to deal with it, and so can you, but at the end of the day, it's a matter for the judge in what order he deals with applications and how he deals with them.
It was undoubtedly up to the judge, but the judge was also faced with the arguments as ventilated as canvassed by the parties. And the argument here from ENRC was there can be no potential prejudice because these categories of documents cannot be relevant, and therefore, we didn't look into them, and the court can exclude the possibility of prejudice. It was that argument with which the judge had to grapple, and he did grapple with it. And in our submission, it is unfair of ENRC to complain that he did grapple with it on its terms.
But does it follow from that that if the judge thinks that more disclosure might be required,
Well,
that he then finds that there cannot be a fair trial?
Well, in our submission, first of all, impossibility of a fair trial, which is the way ENRC puts it, is putting it too high. It is an exercise of discretion which takes account of risk of prejudice, lateness, and explanation for delay. And I'm just about to come to the law. And when one looks at it in that way, through that lens, the judge was quite justified in approaching the case in the way he did, and the structure of his judgment follows, in our submission, the guidance which the courts have given. Now, before I turn to the legal principles and then the judge's judgment, may we look briefly at one other aspect of the transcript, which concerns the reason for lateness. And at page 7 of the internally, page 302 of the supplementary bundle, Pillow said, "Now, my lord, why were they pleaded in the way they were? Why was that pleading left like it was until last year? The answer is that work on analysing the precise losses that ENRC suffered from the investigation and the mechanisms by which it suffered from was put off justifiably in my submission after the bifurcation decision, because it could have proven to be entirely wasted work. It was then in reply that ENRC became rather more candid and apologetic. Page 337, internal page 146, bottom left quadrant, bottom of the page. Position was, my lord, it was given insufficient attention at the time in early 2020 because we were on the cusp of agreeing a bifurcation of the trial. Then line 7, I accept that, my lord, that's not satisfactory, that's not satisfactory. And while we have the transcript, it may be worth just pointing up the point at which Mr Pillow set out how the court should address the amendments. That's page 1 in the transcript on page 301 of the bundle, line 16. Quite a lot may flow from the amendments in terms of case management, so in my submission it would be most sensible to deal with them first if your lordship is happy. And then page 2, and he then suggests that the court may rule as it goes along, so dealing with the amendments first. Now then turn to the legal principles governing amendment and appellate review. And the judge directed himself by reference to the summary of principles given by Mrs Justice O'Farrell in Municipio de Mariano, which is Authorities 23, page 695. Don't need facts in detail. It was the set of claims arising from environmental damage due to the collapse of the Hon Dam. The principles are set out at page 700, drawn from a series of well-known cases which have been approved by this court. And Mrs Justice O'Farrell set out 7 numbered propositions. 1 stresses the importance of applying the overriding objective, including doing justice between the parties and ensuring fair and expeditious resolution of the dispute. I emphasise between the parties because, of course, our interests and those of Dechert are in play, as well as those of ENRC. Point 2, amendment applications always involve a balance being struck between the interests of the applicant and those of the opposing party and other litigants if the amendment's allowed. Then 4, an amendment is late if it could have been advanced earlier, or involves duplication of steps in the litigation costs and effort. And then the statement we've looked at earlier, lateness is not an absolute but a relative concept. It depends on a review of the nature of the proposed amendment, the quality of the explanation for its timing, and a fair appreciation of the consequences in terms of work wasted and consequential work to be done. And that in our submission makes the point about this being a multi-factor exercise of discretion. And then 5, it's incumbent on a party seeking the indulgence of the court to be allowed to raise a late claim to provide a good explanation for the delay. And then 6 and 7 concern very late amendments, the term of art to which my Lord Justice Nugee was referring. And in our submission, when we come to the judgment, the judge was directing himself to follow those principles and laying down the right framework for his decision. The other case, the only other case I need to look at in relation to general principles, is the ABP technology case, which you've already seen, divided 19, page 613. And I need to point to a few passages which haven't already been shown. The first concerns, first is page 619, paragraph 21, where Lord Justice Burse sets out the principles governing appeals against decisions on amendment. And he adopts a summary from the judgment by Mr Justice Simon, where he said that an appellate court will only interfere with a discretion evaluation, which Lord Justice Burse plainly thinks applies to an amendment decision, where an appellant can identify one or more of the following errors: misdirection in law, procedural unfairness, taking into account irrelevant matters, failing to take account of relevant matters, or making a decision which was plainly wrong. And the last of those means exceeding the generous ambit within which reasonable disagreement is possible. And then paragraph 52, he cites again the approval Mr Justice Saini's comment that the appellate court's role is to police a very wide perimeter. It's rare that a judge is exercising.
This is just a general summary of appeals against exercises of discretion.
Indeed.
You take it that the court's very familiar.
I take that on board, but it is important because in this case, ENRC has sought to shoehorn its grounds into error types 1 to 4, whereas in fact it seems to be complaining about the substance of the decision without, at least in its grounds, having had the confidence to say that except in relation to ground 4, finance and NV. Late amendments are addressed at paragraph 23, and that's where Lord Justice Burse emphasises points from the judgment of Mr Justice Coulson in CIP. An amendment is late if it could have been advanced earlier. History of the amendment and the explanation of its lateness is a matter for the amending party and is an important factor in the necessary balancing exercise. Prejudice to the amending party will include its inability to advance its amended case, but that's just one factor to be considered. Moreover, if that prejudice has come about by the amending party's own conduct, then it's a much less important element of the balancing exercise. So it would be wrong to suggest that one just looks at the amendment, asks if a fair trial is impossible, applying what ENRC asserts is a high bar of impossible fair trial. And if that bar cannot be met, then the amendment is allowed. He says at paragraph 24, the simple point about lateness is that it calls for an explanation justifying it, because an amendment which might otherwise be allowed may well be refused if its lateness has caused unjustifiable prejudice. And then at paragraph 31, he addresses a suggestion about, over the next page of paragraph 30, he addresses discusses the concept of lateness being relative. It says it means that an amendment put forward relatively early may nevertheless be late, depending on the consequences of delay. In paragraph 31, he refers to the typical, or the common excuse that we amended late because we were waiting to do everything in one go. Before paragraph 32 saying that one of the judge's concerns was refusing the amendment would have been the result of the court at trial would be applying blinkers to the legal realities. But it's not as simple as that. Several trials are decided based on the issues properly before the court. Once proceedings have begun, the court has power to refuse to permit a party to raise new issues, particularly issues which could have been included at the outset. The power to refuse late amendments which cause unjustifiable prejudice may well have the result that a point is excluded from consideration at trial, which would not have been excluded if it had been raised earlier. And we stress that just because it is an answer to ENRC's attempt to assimilate principles from the strikeout cases with amendment. Now, what we say therefore is that gone are the days that the court simply asks whether there is any prejudice not compensable in costs. Gone are and the days never existed that a party resisting amendment would have to show, irrespective of the other factors, that the court could be absolutely confident that a fair trial would be impossible. Here, ENRC, as I'll say in a moment, tried to face the court with an impossible dilemma of either assuming that it was correct in its assertions about irrelevance of material, or allowing the amendment, or allowing the amendments on the basis that it couldn't be shorter. May I then turn to ground one? And the ENRC has two elements to this. First of all, it says the judge should have applied a test whether a fair trial was impossible in the circumstances, and that's its point about assimilating strikeout principles with amendment. And we say, as I've said, that submission is misconceived because the test is a multifactorial one which takes account of lateness, adequacy of explanation, and degree of potential prejudice. Secondly, it says that the judge wrongly took the approach of requiring ENRC to prove that none of the documents lost could possibly have been relevant. And as I'll say, the judge applied the right test, but he had to address in the course of it an argument from ENRC that none of the documents could possibly be relevant. The ENRC puts this in its skeleton, paragraph 48, by saying, first of all, that there was no real dispute. The main question was whether a fair trial would be possible. That, in fact, misrepresents what the SFO's counsel said. He said specifically that the serious delay and the lack of any good reason for it amounted to a compelling point against the application, and that in the context of the exercise of the court's discretion, the lateness and absence of explanation were significant factors in the balance. That's, my Lord's note, internal page 122, the transcript at page 331 of the supplementary bundle. The ENRC then goes on in its skeleton, again at paragraph 48, to say that an amendment which advances an arguable case should only be refused if the court can conclude that a fair trial would be impossible. In our submission, that's not what the authorities say. None of them says that an amendment which raises and advances an arguable case should only be refused if the court can safely conclude that a fair trial would be impossible. The ENRC then goes on to make this bold attempt to equate the exercise of discretion on an amendment application with the test for striking out a defence or claim where a party has defaulted in disclosure obligations. And it cites the cases of Douglas and Hello, EDNF Man and Mozambique in that regard. But in those cases, the court persistently made the point that striking out a claim or defence which has been properly pleaded at the outset drives the litigant from the judgment seat and deprives him of his right of access to the court. Now, contrary to what my friend says, it doesn't at all follow that the same principles apply when a party seeks to amend. ENRC has had its access to the court, and in seeking to amend, it is seeking an indulgence. It's in that context that the courts have set out principles that I've looked at. As regards the judge setting too high a bar, I said that I would show, my lords, the context and ENRC's contention that none of that all relevant documents would be those of the parent company. We see that in the supplementary bundle, tab 28, page 182. Sorry, tab 20, page 182. Refers to the SFO's concerns about whether a litigation hold has been placed on the documents of the subsidiaries. And then it goes on to say at 89.1, a document preservation instruction was given in relation to ENRC's documents. And the ENRC has no concerns regarding its ability to comply with its disclosure obligations. And our submission, that is a pregnant statement from which one can see pretty clearly Mr. Roberts is not engaging with the question of whether document hold has been placed on the subsidiaries documents, and certainly not with certainly not addressing an argument that the subsidiaries documents will be available notwithstanding. ENRC's skeleton made the same point. This is tab 31.
Is the parent obliged to disclose documents in the possession of its subsidiaries?
Mr. Pillow specifically made clear before the judge that a point was not being taken.
Point wasn't being taken.
About control. ENRC's skeleton for the application is at divider 31, page 343, and it makes the point again at page 360.
Forgive me, you're giving the references a little bit too quickly.
I'm sorry.
Tab
Supplementary, tab 31, page 364.
Yes, thank you.
Paragraph 63. ENRC has made reasonable and considered disclosure proposals that will result in the relevant material being disclosed. And then 64 asserts its position that everything relevant is at group level. So ENRC took upon itself the argument that there could be no prejudice because everything relevant was held at group level. And in our submission, that's why it is unfair to attack the judge for taking that argument on its own terms. We can then go to his judgment against that context. It's at divider 7 of the core bundle. He deals with the introduction at page 160 and the relevant procedural history with a number of the documents I've shown my lords from page 161. 166, he directs himself by reference to the Municipio de Mariana principles and to ENRC's skeleton argument. And he then disposes of the suggestion that different principles apply to an amendment made late in a case where the trial has been split. I'll come back to that a little later. Then from page 168, he addresses the argument summarising paragraph 46, ENRC's argument, that the documents which would have been the subject of disclosure by the subsidiaries are not in fact relevant. And then he then proceeds to summarise the submissions from the SFO. And over the page to 170. He then addresses two aspects of the claim and how subsidiaries' documents could be relevant, namely the negotiation of loans and the diminution of shareholding value. Specifically from page 171, paragraph 55, he sets out in detail ENRC's evidence and arguments that all negotiation of loans was at a subsidiary level, so there could be nothing of any relevance in the subsidiary's document, in the documents held at the subsidiary level. So he takes all that on its own terms before turning to Mr Whitfield's responsive evidence at 62, where he sets out categories of documents which which the SFO have said ought to be disclosable, including a wide range of categories of documents from the subsidiaries. And then at paragraph 63, page 174, he records Mr Whitfield's statement that this material has been requested and required by the experts in order to provide their evidence on increased borrowing costs and its effects. And at paragraph 64, he explains ENRC's response that that essentially could not be right. Now, it was in dealing with that point that he said that he can't be sure that at least some of the documents sought might not be relevant. Difficult to be sure when we've not yet had a hearing on disputed items in the DRD. And that's where he says that ENRC's own request has put matters slightly back to front. But he then goes on to say, to address the various respects in which the documents could be highly relevant, and I'll address those shortly. Paragraph 66, he accepts that the exercise may require documents from the subsidiaries, both in relation to negotiation and then he, at paragraph 68, refers to the position of finance and NV, which I'll address shortly. Then he deals with the diminution in value claim at 176, paragraph 70 to 74, before reaching a conclusion, paragraph 75, that there would be real prejudice to the Dechert defendants and the SFO if the amendments were allowed. And that is real prejudice through an inability to obtain documents of kinds which could be genuinely relevant, contrary to ENRC's intentions.
Jimmy, where are you reading from now?
He has said, for example, at paragraph 73, 177, the lack of documentation now at a subsidiary level constitutes a real prejudice to the Dechert defendants and the SFO, which could have been avoided if the claim in respect of the subsidiary's borrowing had been made at the outset.
So what lack of documentation is he referring to there?
He is referring to the fact that there is a series of categories of documents which we have identified, including documents at subsidiary level. He has then gone through in paragraphs 64 to 69 and 72.
Well, let's just take it through. 64, he says, I cannot say for sure that at least some of the documents sought might not be relevant.
Yep.
So that, as I understand it, he's not saying that there are documents which are relevant. He's not making a finding that there are relevant documents. He's saying he can't be sure that there aren't relevant documents. Is that right?
That is the way he addresses ENRC's argument.
So but just looking now at how he builds up to say that there's a lack of documentation, he is saying that he cannot be sure that there aren't at least some documents which might not be relevant. How then does he get to the finding that there is a lack of documentation? Because that's only talking about talking about disclosability. Where does he find that those documents which might be disclosable are not to be found?
He can't prove a negative. He cannot prove the absence of documents in circumstances where ENRC has not sought to suggest.
I don't think we're looking for proof. What we're looking for is what is his reasoning as to why there is a lack of documentation?
His reasoning is that it has been accepted by ENRC that no document hold has been applied.
Yeah.
He has then addressed ENRC's one argument as to why that couldn't constitute prejudice, namely that no documents held at subsidiary level could be relevant.
But all the judge can say at this stage, or seems to be saying, is that he can't say for sure that at least some documents might not be relevant. And you're right to say it's been accepted that there wasn't a document hold, but how do you get from no document hold, there might be relevant documents, to there is a lack of documentation?
In fairness to the judge, he identifies a series of categories of documents and types of documents which could be relevant to the issues which ENRC's amendments are sought to raise.
Yeah.
And he is not able to say that documents have been lost and documents.
Isn't it extraordinary that you prevent an £80 million worth of claim when the documents might be there, and they might or might not be relevant? You're not going to let the claim go ahead because there might be relevant documents which might not exist.
In our submission, turn it around. It is not satisfactory that the UK taxpayer should face an £80 million claim.
That's really, really irrelevant. That is
no,
really
but
irrelevant.
Any litigant should face an £80 million claim on the basis that although the amendment is significantly late, and although no document hold has been placed, we are not going to tell you what categories of documents have been lost. We are simply going to say, as the judge finds wrongly, that none of these categories of documents held at subsidiary level could be relevant. And in my submission...
Well, the reason you're facing a claim for the damages is because you've been found liable for inducing a breach of contract in 2 trials.
Yes.
And what we now are looking at is the quantum claim in relation to that. So I'm not sure you can be quite on your high horse about facing a claim. And what we have here is there's always been a claim, as I understand it, for these for this borrowing, but it's belatedly been realised that the borrowing wasn't in the name of ERNC, but was in the name of subsidiaries. And that's why we have the late amendment to put forward a claim which is undoubtedly on a different basis.
Yes.
But it's not as though this has come out of left field, and it's not as though you cannot now respond to this claim and including take the point at trial that they cannot prove this claim. Alternatively, that adverse inferences could be drawn against them.
Well, I'll deal with this under the next ground, but adverse inferences at trial are not a satisfactory explanation. That is, of course, a different point from the one the Lordship was putting to me about the quality of the judge's reasoning. That adverse inferences aren't the solution to this problem. Two short reasons. First of all, because our experts need access to the material to which I've referred in order to provide their evidence on, for example, whether the dollar-for-dollar approach is appropriate. And secondly, because we would be faced with the prospect of cross-examining ENRC's witnesses, and specifically its expert, by suggesting, well, what if a document of this kind with this content existed? Would that change your view? And if the expert agreed, we'd be told that we'd be purely speculating, with pure guesswork.
In fairness to you, Mr. Hoffman, what you pointed to on page 177, it's the back end of paragraph 73 of the judgment. For that reason, the lack of documentation, etc. It's based actually on the matter you've just put forward, isn't it? That the judge appears to accept, I think it is, he accepts, that in order to challenge the assertion that diminished in value, the dollar for dollar is not the correct one, that you would need those documents.
Yes.
It's not, it doesn't, what you were saying that it comes from some other part of the judgment, it doesn't really, it comes from that, doesn't it?
Yes. Yeah. Yes, if I indicated that it came elsewhere, then that was my mistake. But let me then come to ground two and the alleged prejudgment disclosure issues, because this is where we look at the potential relevance of the material. And the ENRC argues in this regard, paragraph 64 of its skeleton, that the judge should either have resolved the disclosure issues first, or just accepted ENRC's position in Mr. Roberts' statement. Full and proper disclosure could and would be given by ENRC's own yardstick. Now, the first point we have made in our skeleton in response I've already referred to, which is that it was ENRC's proposal that the amendments should be addressed before issues of disclosure were resolved, and that the judge could rule on that point. The second issue, the second answer, is that the judge didn't prejudge what disclosure would be required. He recognised that there were disputes over the scope of disclosure, but to resolve this application he had to reach a view on ENRC's argument that there could be no evidential prejudice flowing from the admitted lack of a litigation hold. He then approached the exercise carefully, as we have seen, by looking at how the subsidiaries documents could realistically be relevant to the claims which ENRC was seeking to make. And he took account of the fact that the ENRC had not conceded that the subsidiaries documents would necessarily have disappeared, but he also took account of the fact, at paragraph 50 of the judgment, that the ENRC had chosen not to investigate the position and provide evidence on which it had discovered, And that's paragraph 50 of the judgment, page 170. In our submission, that was precisely the right approach for him to take, applying the principles that he had set out. Now, the third point we make in the skeleton is that ENRC suggests that the judge was effectively obliged to accept its assertions and that he ignored its evidence, but he didn't ignore its evidence. He concluded that there were a series of respects in which the documents from the trading subsidiaries could be highly relevant. And if I may, I'd like to address some examples. First of all, first concerns the negotiation of the loans, which we set out at paragraph 53.4.2.1 and following of our skeleton. Now, the plea is that, from ENRC, that the criminal investigation and resultant reputational damage caused the borrowing cost to increase because interest rates offered were higher than they would otherwise have been, and borrowers were unable to refinance at lower rates. ENRC's point, as you've seen, is that because loans were negotiated at the group treasury function level, the relevant disclosure would be confined to individuals at that level, nobody within the subsidiaries. There's very little material that they provided to allow that proposition to be tested, but what they did provide was unpromising for them. And it's in Mr. Roberts' 18th statement and its exhibit, which we see at Supplementary Bundle Divider 29, page 283. Pillow showed you some of this exhibit. But here at 283 we see an email chain ending in a meeting appointment of the 12th of September 2014. At the bottom of page 284 we see an email from Murat Alkanov, an executive in one of the subsidiaries. We know that he's a subsidiary. He's in the subsidiary because he has an erg.kz suffix to his email address. Mr. Roberts has told us in his statement those with an email address ending in erg.kz are from the subsidiaries. Now, he says, please find attached to the revised draft of the loan agreement. The paper has been prepared in Astana with participation of our legal, tax, anti-monopoly and treasury departments, as well as the plans. And then further up page 284 is Jesper Canova of ENRC parent company forwards apparently to Sberbank the facility agreement marked up by our Astana colleagues and suggests that Sberbank revert to Murat Alkanov, that's the man in Kazakhstan, with your considerations. And then following the chain up, we see that Sberbank acknowledges the markup, issues an invitation, and at least some of the optional attendees are individuals with erg.kz email addresses. Now, this is just one of two sets of communications which Mr. Roberts exhibited. So we had limited evidence to work from. But this shows that it's very possible that the subsidiaries which were principal parties to these lending transactions did hold important documentary evidence that's not replicated in the ENRC's document repositories. For example, notes of meetings with lenders or with the ENRC group treasury taken by the individuals from the subsidiaries, communications internal to the subsidiaries commenting on availability of financing and terms, or on reasons for rates increasing. We can't take it for granted that any communications from the subsidiaries to the lenders would have been copied to ENRC Group Treasury. They were, after all, the primary obligors. Now, these categories of documents were within the scope of our disclosure requests in the DRD. So, page 378 of the supplementary bundle, item 20, we put in internal meeting notes. 21, reports and memoranda provided by subsidiaries to lenders. Page 379, item 25, correspondence between subsidiaries and lenders. So we accept we're obviously not going to have the documents from the lenders, but this material from the subsidiaries could be critical to understanding, or could have been critical to understanding the reasons for rates and terms being agreed, options available, and so on. And as I say, we've pleaded that there were many reasons, other than the criminal investigation, why the rates and terms could have been less advantageous in the relevant period than previously. The second category of material concerns comparators. And ENRC has pleaded in its Phase 2 further information one basis on which it can prove increased cost of borrowing is that the rates charged to its competitors were markedly lower. It's identified 18 competitors in footnote 7 on page 106 of the supplementary bundle. And we've denied that these are valid comparators at our paragraph 31 on page 198, including because geopolitical and macroeconomic factors influencing the entity's ability to borrow affected ENRC and each subsidiary separately. That's paragraphs 33.1 and paragraph 33.2 of our document. And in keeping with that, our disclosure requests in the DRD included a series of categories of material relevant to these issues, again based on our experts' requirements. And they're at page 377 and 378. They include contracts into which the subsidiaries had entered, which could impact their revenues, sale agreements entered into relating to deferred payment on projects, lists of significant capital expenditure, internal notes and memoranda. So that's the second category of issue where the subsidiaries' documents were likely to be highly relevant. The third is mitigation of loss, and we've pleaded that the ENRC and the relevant subsidiaries failed to mitigate their loss by not adjusting the conditions on which they were prepared to borrow, for example, accepting stricter covenants. We've specifically put in issue whether the use of debt financing was an act of reasonable mitigation. That's paragraphs 36 and 37 of our further information response. Now, the categories of documents of the subsidiaries which we sought through the DRD could have produced material highly relevant to these issues of mitigation. The same categories I've referred to in relation to comparators would have been relevant here too. ENRC's only answer to this submission before the judge was that our mitigation argument only requires consideration of published accounts. But that in our submission makes no sense. That was internal page 158 of the transcript. It is very possible that contemporaneous documents from the trading subsidiaries make clear what they might have been willing or able to accept in terms of borrowing conditions. And then the fourth category of material from the subsidiaries, which could have been highly relevant to these claims, concerns the DSV basis and Mr Pillow's dollar-for-dollar argument. All the claims, as we've seen, require ENRC to argue that expenses incurred by direct and indirect subsidiaries translated up the chain into loss to ENRC through the DSV basis. The dollar-for-dollar basis to which Mr Pillow has confined himself allows of one qualification, which is tax only. But that self-imposed restriction, as I've said, doesn't remove or reduce the potential prejudice resulting from the failure to preserve evidence. It only sharpens or heightens the importance of our gaining access to material, which might help us to show that the dollar-for-dollar basis isn't appropriate. And in our submission, it is not just a matter of law or expert debate in the abstract. It has to be considered by reference to the facts. And we've put in our references and in the bundle the passages from Marix and Sevileda, not to take a reflective loss point at this stage, but to make the point that the court does not start from an assumption, legal or evidential, that financial loss to a company translates directly into reduction in share value. What the judge concluded in the passages you've seen is that in providing views on whether ENRC's straight dollar-for-dollar basis was appropriate, the defendant's experts would need to consider the particular activities, standing and attributes of the subsidiaries. Now, in our submission, that conclusion was more than reasonable. It's only by understanding the business activities of these trading subsidiaries that our experts can give informed opinions on whether the dollar-for-dollar basis is appropriate. So, for example, we're seeking internal financial projections, and that could provide a basis for our experts to say that information in the internal financial projections could allow our experts to say that added expenses would have had a lower impact on share value. They wouldn't have had simply a direct dollar-for-dollar effect. For example, the expert may say the proper basis of valuation is the DCF calculation, and other projected effects on the company's income streams lessen the impact of share valuation on added expenses. If a share price is going to be hit hard by political risk or trends
What I
in
understand though, what Mr. Pillow is saying is that he takes all this on the chin, and he is going to argue it purely as a matter of law stroke principle, that it's dollar for dollar. And if you're able to demonstrate that that's not right, either as a matter of law, principle, or fact, he loses.
But our experts need to understand the attributes, functions, and projections of these subsidiaries in order to grapple with that issue of fact, which, as my Lord says correctly, is not an issue of law. The idea that it could be an issue of law was effectively disposed by cases like Gerber and Marek.
As I understand it, if it is a matter of fact, if a judge at trial accepts that it could be a matter of fact, then he loses.
But
because he's pinning it on the basis that it isn't.
But for our expert to say that, and one envisages Mr. Pillow's expert saying, this type of company, for this type of company, the dollar-for-dollar basis is the right basis. He certainly won't be saying that the dollar-for-dollar basis is always right for every form of company.
Well, if they say it's for this type of company, then he loses because he is not giving any disclosure as to the type of company.
Well, I don't think he has ever accepted that. If he were to take the position that the dollar-for-dollar basis
this is why I wanted to see exactly what the concession is in writing.
Yes, Mr. Richards put this to the judge at first instance, saying, of course, if Mr. Pillow were to say that the dollar-for-dollar basis is necessarily right for all forms of company, then he might be in a stronger position as regards these amendments. He actually said that to the judge. Strangely enough, in reply, no such wide-ranging concession is appropriate. And your Lordship, with respect, puts your fingers absolutely on the point, which is that if he accepts that the dollar-for-dollar basis may not be right for some companies, then it is necessary to look at the attributes of these companies, and the loss of the document hold becomes critically important. And it's not a point which we can leave for trial to be addressed on the basis of an adverse inference. It has to be either a concession as broad as we've just been discussing, the dollar-for-dollar basis is right in every single case, every single form of company, or we are in a position where we are being disadvantaged as a result of their late amendment.
I've not quite understood that, because we don't know what the material at trial would be. We don't know to what extent the lack of litigation means that there are no documents or reduced numbers of documents. You don't need, as Mr. Pillow put it, to see every email passing between the executives to understand the nature of the company's activity. There may be ample material which indicates that this company is involved in mining chromium in Kazakhstan and that company is involved in selling copper in Zambia. That might be enough. I find it very difficult at this stage to envisage both what material will be available for trial and why and in what circumstances your experts are going to need more than will be available. And that's what I'm finding difficult about this argument. I entirely accept that if it's put on the simple basis that as a matter of law, all companies' dollar-for-dollar basis is adequate, you can argue that as a matter of law.
Yes.
But I didn't understand Mr. Pillow to go quite that far. say that, well, if it depends on things we haven't got, well, then I lose. But we don't know what you will or won't have, what your expert will or won't have at trial, and to what extent that will or won't make it impossible for them or unfair for them to try and argue that dollar for dollar is inappropriate in companies of this type.
What we say is that it puts us in a position of real potential prejudice, of having a whole category of documents, a whole universe of documents belonging to the subsidiaries being impossible for our experts to mine. And that is the problem, that we are deprived of a source of material. And the ENRC sought to say that there can be no unfairness here because none of this could possibly be relevant. Yet the debate we're having shows how it could be relevant. And indeed, the very points your lordships are putting back to me, that this material could be relevant to the exercise, make the point that the judge was entitled to take account of that prejudice as part of, as I say, a multi-factor exercise of discretion.
But once the amendment goes in, you will then have these arguments on disclosure, won't you?
Well, the point of Mr. Pillow's argument below was to permit the amendments in circumstances where, on the basis the subsidiaries' documents wouldn't be relevant. It would have been rather odd to allow the amendments, decide that subsidiaries' materials did have to be disclosed. That would then have established the prejudice we're concerned with when the documents didn't turn up. That's the problem. That's the problem about dealing with the matter the other way round, which of course nobody suggested to the judge. The judge was given the position of the parties together, but he had to decide whether there was potential prejudice as part of an exercise of discretion before deciding disclosure issues. And it's understandable why he did, why he was put in that position. As I say, it may have suited ENRC very well. It did suit ENRC very well to take that course. And as I'm looking at the time, I should probably move on to ground 4 and the judge's treatment of arguments about ENRC finance and ENRC NV. Now, let me deal first of all with the substantive merits of the judge's decision, which are set out, which are addressed at paragraph 61 of our skeleton, core bundle, tab 4, page 65, which we have already, which your lordships have already been shown. We go through this in a number of stages. First of all, 61.1. When ENRC is making its claim in respect of borrowing costs incurred by the trading subsidiaries, so Cascrome et al., its case on how it suffered loss goes through these stages. Cascrome suffers an added expense. That reduces the value of NV's shareholding in Cascrome. That in turn reduces the value of Finance's shareholding in NV. And that in turn reduces the value of ENRC's shareholding in Finance. And then that, on the basis of that, we say at paragraph 61.2 that case treats Finance and NV as transparent. And it treats them as transparent for the purposes of losses being transmitted through the chain by means of reduced shareholding valuations. On that basis, we say at paragraph 61.3, when one moves to the position of claims for loss through increasing borrowing costs of Finance and NV, follows that all the issues affecting the creditworthiness of Cascrome and so on could bear upon the ability of Finance and NV to borrow. And therefore, fourthly, paragraph 61.4, documents held at the level of companies such as Cascrome could be relevant to the claims relating to losses arising through increased borrowing costs of Finance and NV. Then at 61.5 we make the point which my Lord Justice Phillips made in intervention, which concerns the DSV basis. Whether losses through increased borrowing costs of ENRC finance and NV translate to reductions in the value of ENRC's shareholding in finance is an issue that may be influenced by the trading subsidiaries' documents. And as I've submitted, those documents may help us and our experts challenge the dollar-for-dollar basis of claim. And the point we've made in our skeleton is that information about the operations of the trading subsidiaries may show whether reduction in the parent company's profits could result in offsetting changes to the subsidiaries' costs, where the parent is simply a holding company. So those are our points on the substantive merits of this point. It doesn't bear the distinction which my learned friend seeks to place upon it. He makes the specific point that the same arguments could have been made in relation to ENRC's claim for its own additional borrowing costs. And we say that doesn't undermine the judge's decision for at least three reasons. First of all, he had to consider the effect of late amendment and whether it was prejudicial. If the position had been pleaded correctly at the outset, the bulk of the borrowing was by subsidiaries, then steps would have been taken to preserve their documents. So the simple point is that a late amendment has put us in a worse position than we would have been in, including in relation to finance and NV, if the case had been pleaded properly at the outset. Secondly, we didn't know until we saw the amendments that we would have to grapple with the question whether increased expenses at subsidiary level translated into diminution in shareholding value on a dollar-for-dollar or some other basis. And so as we've submitted, the subsidiaries documents would have substantial relevance to that question. That question simply didn't arise on the original pleadings. And thirdly, as we put it before the judge, the fact there may have been a gap in disclosure doesn't mean that the court should agree to amendments which make the gap more obviously significant. As to ENRC's procedural criticism, we've addressed this in some detail at paragraph 63 of our skeleton. In short, what we say is that in this case, the essential building blocks of the analysis the judge adopted were clear, namely that the apparent absence of documents of the trading subsidiaries could prejudice the ability of the defendants to take issue with the proposed claims. I would also note that Mr. Millett did make the point, specifically, that the dollar-for-dollar basis arose in relation to, he made the point about concerning sub-subsidiaries and the dollar-for-dollar basis, page 334 of the bundle, internal page 133. So in our submission, the judge did not take a point which had not been within the scope of the argument. And also, if ENRC had genuinely felt that there was a deficiency in the judge's expression of his reasoning, then it could and should have raised that when the draft judgment was circulated, one of the limited purposes for which a draft judgment can be addressed. So, for those reasons, we say that the position of finance and NV is not to be distinguished from the position of the other subsidiaries. We have once again been deprived of the opportunity to insist on categories of documents being preserved undisclosed, which could have been highly relevant. I haven't dealt with ground 3 because it wasn't pursued. Ground 5, concerning what is a late amendment, I think I've addressed in the course of dealing with the authorities. In summary, this was a late amendment which risked material prejudice to us in defending huge claims, and the potential size of the claim, which is of course itself highly disputed, may have significance for ENRC, but of course it has significance for us to the extent that we are required to defend a claim without proper evidential resources. Mr Justice Waksman, who of course knows the litigation inside out, applied settled principles. He didn't apply the wrong test. He directed himself correctly in law, and he reached a conclusion which was well within a reasonable range of judgment. The alternative option of leaving us to deal with these amendments at trial without our experts having had the opportunity to consider, it would appear, any material subsidiary level would have been thoroughly unfair and unsatisfactory, especially in the context of a very large claim. ENRC may complain that it's been shut out from making claims, but with respect, it should dismount from the high horse as well, because, in the words of Lord Justice Burse, it is the author of its own misfortune. May I just check that there is nothing I have omitted? Thank you very much, my lords.
Could I just ask you to go back to paragraph 50 of the judgment?
Paragraph 50, yes.
What do you say the judge is actually finding? He's recording the ENRC's argument that effectively the documents may still be there, or some of them may still be there, and that if then there are amendments and it's necessary, ENRC will investigate. The judge then says, however, all of that is far too speculative. What would have been useful if they'd already checked, for example, keywords. Not undertaken that exercise, and is somewhat not surprising it's not. What do you say that? What finding, if any, is that? Is he finding that the documents aren't there, or is he finding that the risk that they're not there?
In my submission, what he's doing there is responding to Mr Pillow's submission on, I think it was pages 55 and 56 internally, to which I took your lordships, where Mr Pillow said, who knows, the material, that some material from the subsidiaries may be there, but we haven't looked. And what the judge says is that in circumstances where the need for this material has been raised, and ENRC has chosen solely to put forward as its disclosure proposals material from topco level, he has to address the arguments before him, and it is not good enough for ENRC to say there can be no prejudice because the documents are irrelevant, because the judge deals with those points and says they could be very relevant. And here he says it's no good for ENRC to say, well, who knows, there may be some documents that have survived, but we haven't looked.
So is this the foundation of his reference later to lack of documents?
This is part of the chain of reasoning which causes him to say, ENRC has had the opportunity to tell me that documents may have been preserved. By the same token, ENRC had had the opportunity to say that documents would have been lost anyway. None of that effort was made, and the suggestion that it was not made as a result of proportionality is very thin.
I just have one question, which is the point you made a moment ago about the size of the claim. I mean, I understand that it's more prejudicial to the defendants to be facing a larger claim, but equally it's more prejudicial to the claimants to lose a larger claim without a trial. How does it affect the exercise that the judge was engaged on, that it's a substantial claim?
Well, obviously, in a sense, the value of a claim and potential prejudice aren't easily commensurable. It's not weighing one sum of money against another. What the judge has to do, and this is why it's a discretionary exercise in our submission, is try to balance considerations of the effects on each party, taking account also, as I've said by reference to ABP, the period of lateness and the quality of the explanation for delay. In my submission, the judge does that, and in answer directly to your Lordship's point, the prospect of facing a claim from effectively an entirely new group of entities. I appreciate it's still ENRC making the claim, but a new group of entities are being put forward as those who have actually incurred the original expense, without knowing that we'll have any material. That is, in the context of a big claim, a weighty factor in the balance. I don't think I could be more precise about it than that it is a very weighty factor in the balance.
But if all of these loans had been in the name of ENRC, this issue wouldn't have arisen. The fact that they've been structured as the subsidiary, as the name borrower, with ENRC as the guarantor, plainly that changes the legal liability for the loan, but you're building a very large construct out of what is a relatively, in business terms, something could be done either way. It could have been done that the group took the primary liability, and it seems to me the whole edifice here is rather artificial.
In my respectful submission, not, because the fact that the subsidiaries of the primary lenders opens up
Borrowers, yeah.
Principal borrowers opens up this universe of additional documents to mine. And if it was suggested that we wouldn't have troubled to mine it, then the RFI and the correspondence that follow it gives the lie to that suggestion, which is one of the reasons I took the court to those.
No, I fully accept that you would have taken any and every opportunity to maximise your defence.
Or to inform our defence, to give us the straw with which, the evidential straw with which to make forensic bricks, the ability for our experts to say, wait a second, the dollar for dollar basis isn't appropriate because of specific information we get about these subsidiaries.
Thank you very much.
Thank you very much.
My Lords, thank you for the opportunity. I wish only to add a very little to what Mr. Huff has submitted to your Lordships. Can I just start with a very obvious overarching observation? This is an appeal on the judge's exercise of his discretion in the kind of application that comes before the commercial court week in, week out. And your Lordships certainly need no education on the principles. It was remarkable that Mr. Pillay, during the course of his submissions, didn't really go to the judgment at all and identify precisely wherein the judge had failed to take into account relevant matters, had taken account of irrelevant matters, or, on the whole, the judgment was plainly wrong. And it does fall to your Lordships to have to do that in order to be able to overturn the judge's discretion and either exercise none of your own or replace it with a fresh exercise. We were really treated to a rehearing. My Lord, against that background, I want to make, I think, 4 observations very briefly. The first is this. The way that ENRC has framed its appeal, it ignores much of the way in which the arguments developed before the learned judge. Can I just start by showing your Lordships paragraph 46 of the judgment, which is at page 169 of the 4 bundle, where the learned judge summarises ENRC's submissions, and he says in the second sentence, the first main point is that the documents which would have been the subject of disclosure by the subsidiaries are not in fact relevant to the borrowing costs at all. Accordingly, their absence does not cause the SFA or the Dechert defendants any prejudice. All of the relevant documents can and will be to some extent have been disclosed by ENRC and its successor ERG. And then at 64, on page 174, the learned judge goes on and answers that question. I think in the context both of borrowing and subsidiary valuation. And he says in the middle of that paragraph, without more detail, I cannot say for sure that at least some of the documents sought might not be relevant, and it's difficult to be sure where we have not yet had a hearing of the disputed items in the DRD. And then he goes on to make the back to front point, but only as a result of being asked to do so by ENRC, as my learned friend Mr Huff has pointed out. Now the point, my lord, is this, that the proposed test put forward by ENRC was that a permission to amend should only be refused on grounds of concerns about the completeness of the amending party's disclosure if the court can be satisfied now that a fair trial of the proposed new claims was impossible. And we get that formulation from ENRC's skeleton before the learned judge, which we find at Supplemental Bundle tab 31 at page 357, paragraph 42. And if your lordships look at that, it doesn't come up on Opus. 357. They say at paragraph 42, there are, and this is in relation to alleged prejudice and fair trial and disclosure, there are two answers to these complaints. First, concerns about disclosure can only stand in the way of the amendments. And then this, if the court can be satisfied now that a fair trial is impossible, underlined, an analogy can be drawn to the much more extreme context of applications to strike out for deliberate destruction of documents, where the court will not strike out the claim unless a fair trial is impossible, and this is exceptional. And the EDNF Man case is cited in the footnote. Now, my lords, what underlies this entire appeal is that false premise. There is no analogy with strikeout for destruction of documents, deliberate or otherwise. There is no analogy with fair trial objections. And in our submission, it's not surprising that the judge rejected that and opted for the more customary approach of a more general and nuanced prejudice. First, the discretions in these fields of operation are completely different, and they operate in different contexts. To strike out an action based on allegations that are already pleaded is a major step, depriving the claimant of access to justice. It engages Article 6 and other more domestic considerations. That is a completely different exercise from deciding whether or not there's prejudice such as to allow or to shut out an amendment to a new claim.
Does an amendment application engage Article 6?
Follow, I'm sorry?
Does an amendment application engage Article 6?
No, well, it doesn't. We say it doesn't because there's no access to justice difficulty in relation to an existing claim. What the applicant for an amendment seeks to do is to crave an indulgence from the court to add something new which he didn't add before. And there may be good reasons for that, and there may be no good reasons for that. And the question then is a more general analysis of the balancing of prejudice.
But the refusal of the application does deny him access to a claim for $80 million, which he says is a good claim. Why is that not an Article 6 question? There may be an answer to it, but why is it not a question of access to the court?
But for the simple reason, Lord, that the starting point is not an existing claim which the applicant is seeking, which the applicant for a strikeout is seeking to remove. It's simply the boot being on the other foot. That's the short point. But Lord, the second point is the adoption of the same test would place an impossible burden on the party facing the amendments, because that party can't prove what it can't know, and which the applicant indeed can't know either. Third, my lords, it would be bad law, because it would amount to a free hit for a party to destroy their documents and then come to court many years later and ask for permission to amend to plead a case to which those documents, let's assume for the moment, are potentially relevant, and then get it because the other side, the party facing the amendment, can't prove what is a high standard, that a fair trial is impossible without them, and then only put them to proof on grounds that a fair trial is impossible. In other words, to substitute.
That same argument applies to somebody starting a new claim, doesn't it? Exactly the same position would apply. They could destroy all their documents before starting proceedings.
That's true, but the circumstances in which you might start a new claim would be different. And I see the lordship's point, but starting a new claim may engage different considerations as well. You may have to discontinue the first. There may be cost considerations. But the point is, it all lies in the discretion of the court in the usual way. Fourth, my lord, it ignores the false premise which the ENRC starts from, led it to its submission that a fair trial was possible on the basis of the documents that ENRC considered were enough to prove its new case. Now, that is not a proper basis for the grant of permission to amend, and particularly not where, and I'll come back to this in a moment, where lateness was potentially causative of the lack of documents, and where the lateness is wholly inexcusable, as Mr. Pillow was constrained to accept to before the learned judge. And my lords, what we say about that is the judge's decision that the absence of document retention mattered is clear from the judgment. It is ENRC who essentially elided the question of relevance with the question of existence and possession. In fact, my lords, and your lordships will have the references, I made the point in my own brief oral submissions to the learned judge, and it's the transcript at Supplemental Bundle, tab 30, pages 333, at pages 131 and 132 of the manuscript, and also our skeleton below before the judge at paragraphs 36.2 to 36.4 at Supplemental Bundle, tab 35, pages 408 to 409, essentially that ENRC had come before the court having failed to make the relevant investigations, and therefore put itself in the position whereby it didn't know what it didn't know. And from that negative starting point, attempted to put a positive burden onto the SFO and Dechert. And the judge saw through that, and he was right to do so. So he impliedly accepted that there was a lack of documents, which had been caused by the absence of a document hold, in circumstances where it was open to ENRC to say, well, we've looked at everything up to 2019, and these are our document retention policies, and they'd all gone by 2014 or 2016, or at any time before 2019. But they didn't do that. And the judge was perfectly entitled to draw the inference that that mattered, that the gap having been caused by ENRC in its own knowledge was something which pointed in the wrong direction.
Did he draw that inference?
Well, as we say, he draws it tolerably clearly, but sufficiently clearly not to be the subject of an attack on appeal here.
So where do you say he did that?
Well, I think it's implicit in I say it's implicit in the various paragraphs that have been referred to, such as paragraph 64 and 67 and 73. Well, if your lordship is looking for a black and white statement, then I think I'm constrained to accept that that is not there. But in our submission, that is not
well, he seems to have
attack on the judgment.
He seems to have come to the conclusion that there is a lack of documentation. But he doesn't anywhere seem to have considered whether that is by virtue of documents not having specifically been retained as of 2017
No.
or 2019.
That's true, my lord. But if Mr. Pillow had got up before the judge and said, well, your lordship isn't able to make any conclusion one way or the other about the effect of the lack of document retention, the judge would have said, well, it's for you to tell me. So it's hardly a submission he could have made, and therefore the judge can't fairly be blamed for the deliberate gap in the evidence caused by
yes,
ENRC's
normally
decision.
what you'd expect to see is the judge make that finding. What we're looking at what his findings were.
Yes.
And what I don't see in the judgment, and maybe I just missed it, is the judge making any finding that the reason why there won't be a response to disclosure is due to the fact that no document hold was put on in at the time when he thought the amendment should have been made.
No, well, I think we all accept that that's not there in black and white, but it's certainly implicit. And if it's, but that fact itself is not a good reason to disturb the judge's decision. And the reason for that, my lords, is that it would essentially reward the ENRC for having failed to do what it could and should have done, which is to take the a priori point and say, before you get to relevance, well, these are our policies, this is what happened, and there's nothing to see here. There was no problem, there is no gap, there is no lack of documentation to speak of, which it did in respect of...
Anthony ENRC's position was this. These are our subsidiaries in Kazakhstan and elsewhere. Obviously, if this amendment is allowed, then there'll be an argument about disclosure, and if we're ordered to give disclosure of certain categories, then we'll see what documents there are. What we don't have to do before we make an amendment application is do a disclosure exercise.
No, but what you do have to do in circumstances where the point has been raised squarely against you by Mr Whitfield in Whitfield 4 is to respond and say, well, actually, we now have gone and had a look and seen what the policies were. Not every single document. That is an excess of enthusiasm by Mr Pillow. The very minimum that Mr Roberts could and should have done would be to have taken the point on board and actually looked to see what the effect of the lack of document hold was on the relevant subsidiaries, at least to the extent of whether or not, in fact, there may well have been no destruction at all. For all your lordships know, the documents are still there because they have no destruction policy. For all you know, they were destroyed after 1 year. We don't know. They're all in all sorts of different jurisdictions where doubtless there are different requirements.
That's why it's a little bit uncomfortable not permitting the claim to even go to the stage of disclosure.
Well, the stage of disclosure, that was precisely because the ENRC said, decide this now before we get to disclosure. And, as your lordship heard from Mr Huff, in the face of a very substantial request for putative disclosure based on the experts to say, well, if these amendments come in, this is what we want to see. So, my lords, that isn't a point that Mr Pillow can raise in his favour either. My lords, can I take your lordships, and I'm grateful for those behind me, to those behind me, page 170, paragraph 50. This is what the judge says here. He says, it's not even clear that there are now no or a reduced set of documents which could be disclosed by the subsidiaries. It may be found that they're still there, and if the ENRC is allowed to have its amendment and is later asked to investigate...
Well, this is the paragraph I asked Mr Huff about right at the end, isn't it?
Yes. What would have been useful is that they'd already checked, but it hasn't undertaken that exercise, and it's somewhat surprising that it hasn't. But Lord, we say that the gap between that comment, or that criticism, and his conclusion that the absence of a document hold led to an absence of potential relevant documents is too small for this court to bridge by allowing the appeal.
Well, all the judge actually says it would have been useful if they had, and then they could have argued that the absence of a litigation hold did not matter. However, and is somewhat surprising. So I'm not sure what he's actually found there in concrete terms.
Well, I think what he's found, my submission is that what he's found is that ENRC is to be criticised for coming to court in the face of an allegation that there was no document hold on potentially relevant documents and not being able to satisfy the court that that objection at threshold was unfounded. And that he was entitled to make that observation and entitled to go from that observation to find that there was a lack of documents. Because otherwise, what it allows Mr. Pillow to do is to stand in court and say, well, I haven't bothered to look. We have no document hold in respect of all of these subsidiaries except two, where we do know there was a document hold. We know there was no document hold in relation to the rest, but we haven't bothered to tell you whether or not it had any effect. And then to say, don't worry about any of that, because the documents are all irrelevant anyway.
Well, what the judge seems to anticipate is if they had done a keyword search, then they could have argued that the absence of the litigation hold did not matter because there were no responsive documents. I don't quite understand that, I have to say.
Well, they could have done. They could have dipped in.
Keywords, and if documents did emerge, then they could have argued there were no responsive documents.
Yeah, only by way of an example, all the judge is positing here,
Yes.
one way of going about testing
Yes.
the causative effect of the absence of a document hold. But in our submission, he is not to be criticised for not, if you like, adding a short sentence to say, I'm very surprised, and therefore I infer. And it's obvious in our submission that that there is no effective absence of a finding of fact in this judgment. And that is not surprising given the way in which it was put to the learned judge. And the focus was all on relevance. The entire court proceeded, and we say it was impliedly accepted during submissions, that the question of the impact of the document hold was only about relevance and not about existence or possession. The sole question was relevance. My lord, my learned friend, and this is the second of my observations, the second of my observations is that ENRC repeatedly positively represented that a fair trial was possible because it will disclose all relevant documents. I'm just going to give you, lordships, the references. Skeleton before the learned judge, paragraph 44. This is ENRC skeleton at supplemental bundle, tab 31, 358, the relevant documents. We say that means all relevant documents. Skeleton at 49, page 359 of the same bundle. Skeleton at 59, where page 363, where they say under the heading of DSV, the relevant documents are available. And that clearly means all relevant documents. And to put it out of doubt, skeleton at paragraph 64, at page 364, and I quote, even if, which is not the case, there were any difficulty with the ENRC disclosing all relevant documents. And that, in our submission, is an unequivocal representation of fact that no relevant documents were not retained despite the lack of a documents hold over the subsidiaries. And my lord, that reflects Roberts 18, paragraph 21, at supplemental bundle, tab 28, page 257, where Mr. Roberts says pretty much the same thing. So, my lords, it's not surprising in our submission that the learned judge expressed scepticism about that. If ENRC had not investigated what it had destroyed and what it had retained, and therefore we were in a universe of ignorance, it was an impossible assertion for it to have made. In short, it didn't know what it didn't have. My lords, it's not an answer to say, don't worry, you can have another go at trial, because at trial, the exercise would then become an application essentially to strike out or make some sort of similar positions on the basis that a fair trial is not possible. That is a different exercise with a very much higher threshold. It isn't a question of kicking the can down the road. It's a different can. My lord, so far as dollar for dollar is concerned, this is my third and very short point. My learned friend Mr. Huff has made the point, but we would ask this question rhetorically of Mr. Pillow. Is he prepared to concede that if our experts say in their report that they cannot opine on methodology or test the dollar for dollar approach without specific documents from the subsidiaries, he must lose. The answer to that is, of course, he's never going to accept that. And therefore, what you'll end up with is the spectre of a trial at which both sides' experts get cross-examined, not about the methodology per se, but about the presence or absence of the evidence to support it. Now, that's entirely unnecessary if you disallow the amendments. We simply go to the question of whether on the existing material the extreme position taken by Mr Pillow is right or wrong. We're not going to argue about it now. We say it's plainly wrong, and it may be a very short trial, but that's neither here nor there. What you can't have is a position where the experts are actually unable to formulate a view in accordance with their instructions without the relevant documents with which to do so, which is why in all cases the expert evidence comes last, after disclosure and after witness evidence. It's so that they have the entirety of the material on which to be able to perform their role. Otherwise, they become experts in document relevance. The experts are not being called on the question of document relevance. They're being called on the question of valuation. So, at least on that point. My lords, finally, lateness. Lateness is a relative concept. It's now become almost statutory. Relative to what? And the answer in this case is relative to the time when potentially relevant and disclosable documents were destroyed. And it is for ENRC to explain when that was and why delay isn't material. My lord, it's that time lag. And in the absence of that explanation, we have been put deliberately in a position by ENRC whereby we are unable to measure the relativity, if you like, of the time lag between the destruction of documents and the bringing of these claims by an application to amend. Lords, unless I can assist your lordships further, that's what we would say.
Thank you very much. My lords, can I first of all just deal with the point made a couple of times by Mr Hoff? Because you will have noticed in his submissions that he is now no longer saying there is a risk of a prejudice to a fair trial. His words didn't come out of his mouth any more than they're in his skeleton. What he now chooses to be the label for the prejudice he seeks to balance in his side of the scales is what he calls evidential prejudice. You'll see that at draft transcript pages 2 and 45 today. And that is not the case that was advanced before the judge. And it's not the question before the judge or the question on appeal. The question on appeal is whether whatever established evidential prejudice there is led to such a risk to the fairness of the potential trial that the weight of that consideration outweighs the risk, the prejudice to ENRC of having its case blocked out on the amendment stage. And what my learned friends seem to be hesitant to seek to establish in this court is that there is in fact a link capable of being made at this point, prior to disclosure and prior to the production of documents, between the possible absence of possibly relevant documents and the potential unfairness of a future trial. That's because they can't establish that link, and the judge didn't make the link, and that's one of the errors in his analysis. And unless you make that link, you can't do the weighing exercise that's at the heart of an amendment application, and that was why I say grounds 1 and 2 are correct. It's quite telling that the terminology has changed, because that's what they have to do to try to meet the situation they're in. My learned friend, Mr Millett, just said that there is no analogy with the fair trial objections, and it's not surprising, he said, the judge opted for what he called the more customary approach of a more general and nuanced general prejudice. And it's the same point. There's a rowing back by both sets of defendants from any attempt to prove what they set out before the judge to prove, which was that there was a real risk of unfairness at trial. And I opened the case this morning by showing your lordships what Mr Millett said in his skeleton at paragraph 46, which is exactly that was the prejudice they relied on. That's supplementary bundle, tab 35, page 412. My Lord Justice Phillips put to Mr Hoff that the only point he had
was that it's possible that some documents have been destroyed between 2019 and 2024. And I'd certainly endorse the thrust of that question. But, my Lord, it's worse than that in a sense for the SFO, because the SFO have previously accepted that these amendments would have been in time, if you like, not late, not too late, had they been brought at the end of 2022. You'll see that in their skeleton before the judge. It's Supplementary Bundle, tab 34, page 385, please. Paragraph 8. And their position until today was not that these amendments ought to have been made in 2017 or 2019 and would be too late at any point thereafter. It was that they ought to have been made at the very least by or shortly after the 29th of November 2022. There are reasons for that, and it's about the way in which a similar issue arose at trial of the Phase 1 action at around that time. But it's very clear from paragraph 8 that before the judge, there was no suggestion that had we made that application, this application shortly after the 29th of November 2022, it would have been suggested it was too late. The contrary, that was said to be the point, the period. Now, my Lord, that means, of course, that the only point my learned friend Mr. Hoff actually has is that it's possible that some documents have been destroyed between the end of 2022 and November 2024, which is an even smaller window in which there is even more uncertainty as to whether any documents at all have been destroyed or lost at all. And my learned friend Mr. Millett, in his final comments just now, said to your lordships, you don't know when documents were destroyed. My lords don't know whether documents were destroyed, nor does he. There isn't any basis on which to suggest that documents have been destroyed. There's only the possibility that they have no longer been retained because of the lapse of time and the absence of a litigation hold. And I'm leaving aside envy and finance, obviously, because there is a litigation hold. None of these points hit that mark at all. So, my lords, that's the window. And in my respectful submission, Lord Justice Phillips was correct to say that this turns on the question of whether it is possible certain documents have been lost in that 2-year window, bearing in mind that the window starting in November 22 was already 9 years after the relevant events started in 2013, and 6 years after the end of the period with which we're concerned, which is 2016.
Did you make that point to the judge?
I can't remember that I did, my lord. But in any event, of course, it's the answer to what my learned friends are saying to you now, because they can't run a case below based on a date of November 22 and now say, oh, we've got to go all the way back to 2016, 2017, and 2019, in fact.
Well, yes, then it wouldn't be an amendment.
Quite. But it would, of course, it would if it was a day later. But that can't possibly make a difference, and we're back to the point about the substantive outcome being the same, all other things being equal, whether it's an amendment application or an original claim. Now, my lord, again, Lord Justice Phillips asked me to tell you where I invited the judge to consider and decide the disclosure issues on the amendment application, and I said I'd come back to it. May I do that? The answer is in the transcript, not at pages 1 and 2, where we were setting the agenda, but at page 21, Supplementary Bundle, tab 30, page 306. And you'll see I'm opening at page 20, page 21 of the transcript, line 9, page 306. I'm opening the amendment application, and I've said the two questions for your lordship really on this amendment application are what types of disclosure, what types of material are reasonably required to be disclosed to have a fair trial, proportionate trial of the issues that we're trying to plead. And secondly, can ENRC give that disclosure? Lines 9 to 14. So the very disclosure issues we've been talking about today were the ones that I invited the judge to say were the ones that needed to be decided on the amendment application. And answering the second one, can ENRC give that disclosure, answered the amendment application. So once you've decided what disclosure is required and whether ENRC can give it, then the amendment application follows. But it follows from that moment that I was certainly asking the judge to decide the issues, partly, of course, because we were all dressed up and ready to go with all of the DRD materials and so forth.
When you were saying on this application, were you then referring to the amendment application?
Yes, my lord, this was the point at which I'm dealing with the amendment application. I've just started opening. And in fact, you can then see, if you go forwards to page 30 of the transcript on 308 of the bundle, that we even get into the DRD documents and the models for disclosure that are being proposed by the Serious Fraud Office. And we go through, and I make points about how their proposed disclosure is too broad and not necessary, disproportionate, and so forth. And you can see that, if you want to have a quick glance at it, at page 376 of the bundle, because this was what we were, or the equivalent of it was what we were looking at. This has actually got our answer to the points in the DRD served by the SFO. But you'll see that we were arguing on the amendment application whether the requests for disclosure in the DRD in red were actually necessary for disclosure to be given fairly, for a fair trial. And the debate was, should the red words be in, should they be out? And we went through them and I explained why we submitted this was all too broad and unnecessary.
Yes.
And you'll see it at pages 77 to 78 of the transcript, back at page 320.
I haven't seen the DRD for a while.
Your Lordships no doubt view that as one of the benefits of elevation. But that makes the point, my lord. This was what we were looking at, to try to make the point that our arguments about what was reasonably necessary to be disclosed were right, and theirs were wrong. And my learned friend is therefore constrained to say that that was a debate that was had on the amendment application, because I urged it. But that is the very thing the judge refused to entertain, or at least refused to decide, because it was back to front. But had he decided it, in my favour, for example, we would be moving forward with the amendments and no subsidiary documents required to be disclosed. And that's really the proof of the pudding. Because we were never allowed to get to the stage of persuading the judge we were right, we never got a fair hearing of whether the documents we say were relevant for the exercise were the ones that were relevant, or whether the SFO was right.
So should we be allowing your appeal, do you say, or should we be sending it back to the judge?
You should be allowing the appeal, my lord, because the reality is one needs to have the pleaded issues before one can now have the pleaded issues and then look at the document disclosure. It would be, because the trial's now been fixed, it would be a retrograde step to start reversing the timetable.
What do you say the judge did in paragraph 50 of his judgment?
What the judge did in paragraph 50 of the judgment was to say there is no actual evidence to show whether documents were destroyed or not, and when, or if I could put it the other way around, to show that material that might have been available is no longer available, or vice versa, and to express his surprise that we had not done that. But my lord, that can't plug the gap in the analysis. The judge was saying, well, you could have already checked with the subsidiaries. And I think the evidence was, or at least my submission at the time was, that we were going to ask the subsidiaries what they had, but we hadn't got the answers. But anyway, the judge noted that was the position. But that doesn't help cure the problem of principle, which is unless you know there are things that are missing, you can't make a meaningful assessment of the weight of prejudice in the sense of a risk to the fair trial.
So when he says in paragraph 73, refers to the lack of documentation now at subsidiary level, what's he referring to?
My lord, I'm afraid he's made an assumption that is unjustified by the evidence or his prior reasoning, that as a matter of fact, documents will be unavailable, because there is no evidence that they will not, or there is unsatisfactory evidence that the documents my learned friend's clients wanted to see may still remain. But that sentence is one of the errors we rely on in our grounds, because the judge approached this whole section of his judgment with the mindset, not that there was a risk of a potential lack of possibly relevant documents, but that there was certainly a lack of definitely relevant documents, and that's the error. Can I just, for the transcript, I was going to finish answering your Lordship's question from earlier by showing you the skeleton at the CMC, tab 31 of the supplementary bundle, page 343. That is where I can show, you can see that we did invite the judge to deal with the amendments first, but that meant grappling with the relevant disclosure issues at the same time. And you'll see, for example, at page 345, paragraph 5.1, little 2, under the heading Amendment Application in the 2019 claim, at top of 345, we say, we recite the SFO's claim that a fair trial is not possible, etc. And we say the answers are simple. ENRC can and will give proper disclosure. And there is no sensible basis on which the court could now conclude that a fair trial is impossible, etc. And that was, so that answer, that ENRC can and will give proper disclosure, was part of our answer to the amendment application objection. And we go on in the skeleton in section D4, from paragraph 40, page 357, to set out our answers to the alleged prejudice claimed by the SFO in terms of fair trial and disclosure. And at 43 in particular, you can see our answer to their amendment objection is ENRC's evidence is that it can give proper disclosure. The SFO's complaints amount to no more to mere attempts to cast doubt on this, including claiming that it cannot test the evidence, that it can't be said that a fair trial, etc. And secondly, and contrary to the SFO's position, the detailed evidence before the court demonstrates that a fair trial will be possible because ENRC will disclose the relevant documents. And then we go through, under the headings that follow between 45 and all the way down to 57, 58, 60, so on, why the evidence establishes that the proper scope of disclosure, if the DRD exercise was finished, would vindicate our view of the world and not the SFO's. And that's the back to front point that the judge declined actually to decide, and instead say we hadn't proved that no conceivably relevant documents could possibly have been lost due to the absence of litigation hold. And the punchline is in paragraph 63 of that whole section at the very end, where we say we have made reasonable and considered disclosure proposals that will result in the relevant material being disclosed. If the judge had determined that question, whether we were right on that submission, he would have resolved the DRD points, and we would know whether subsidiary documents were in fact considered to be reasonably disclosable for the various issues that arose on the amendments. But we don't know that. My Lord, can I make a small point? And I'm conscious of the time, but if you just indulge me for 2 more minutes. The point about, one of your Lordships asked about practical control. I think it was my Lord Justice Nugee. And my learned friend said, oh, it wasn't an issue. I didn't take the point. It's not quite as simple as that. If I can show you the transcript, please, at page 314 of the supplementary bundle, internal page 56 of the transcript from the hearing below. What I actually said to the judge was that we had taken the point in the past that our subsidiaries, we're not the legal controllers of our subsidiaries' documents, and that is true. In other words, I was taking a legal control point, and I then make the point that it's just clearly a right proposition. If it's going to be suggested, I said, that we have practical control, perhaps if we ask we might be allowed to look at what they've got. In other words, I was prepared to say that if we were asked, or it was suggested by the other side that there was practical control, then we would go and ask the subsidiaries for their documents and see what they said. But we didn't concede that we could have put a document hold over the subsidiaries in legal terms. I did not concede that point, as far as I'm aware, but I did say we would ask them, and if they do agree, we would be able to disclose the material. But there is no particular objection to that sort of approach. That's what was said about it. Finally, then, can I just deal briefly with the dollar for dollar point to close that off, if I may? My learned friend's case for the SFO, Mr. Huff said, our experts need to understand the attributes of the subsidiaries to grapple with the dollar for dollar case. That's the point they are trying to make. So the first point we can say, and he says, we may not be able to do that because there's no litigation hold. The documents may have gone. So the first point to make is that does not apply as an argument in relation to envy and finance, because there is a litigation hold, and we're back to that same question. So when he says my experts want to mine the documents, apart from saying, of course, that's not how disclosure works nowadays, you have to prove that they're reasonably necessary for the fair resolution of the issue. You're not just given everything you possibly want and told to mine them. But leave that to one side. The documents are there for envy and finance to be mined if he wants them. That's not in the issue. The question of substance, though, is whether you need the subsidiary or the trading subsidiaries documents to understand or to tell his experts what are the attributes of the subsidiaries that are relevant to the question of whether loss is suffered on a dollar-for-dollar basis by the parents. Now, our expert says, of course you don't need the documents from the subsidiaries to tell you that. You get everything you need for a dollar-for-dollar analysis from the material that is available from the various sources that everyone accepts are subject to retention or in the public domain. And we summarise those in front of the judge in our skeleton below at paragraph 61, supplementary bundle page 363. And it was our clear case below, and if you look at 60 to 61, 60 says ENRC understands that in order to calculate the difference in value resulting from the subsidiary costs, it will be necessary to calculate 1, the ownership interest in the subsidiary, 2, the costs incurred by the subsidiary, and 3, any savings to the subsidiary arising from the fact that it incurred the costs, e.g. in its tax bill. As to 1, ENRC has provided its consolidated accounts which show its ownership interests. As to 2, it's provided the P2FI, that's the Phase 2 Further Information Schedule, and all of the many thousands of invoices showing the costs incurred. And as to 3, ENRC intends to produce audited financial statements of all of the relevant subsidiaries, which should show how the relevant costs were treated for tax purposes, the effective tax rates, and they'll produce all records of dividend payments made by the subsidiaries. Now, so our case is that those documents which are undoubtedly available will be all that you need as an expert to opine on dollar-for-dollar loss. Our point, so our primary point before the judge was, you don't need any more because the experts can do it on that basis. The SFO said, no, our experts think you need more. And our concession before the judge was, well, if you do require such documents to answer that question, and they're not disclosed, then we will lose the case. That's the concession. If your expert persuades the judge that the material that isn't available is actually necessary to give a proper answer to the question of whether there's been a dollar-for-dollar loss, then we accept we will not win the case.
You don't accept Mr. Millett's suggestion that if their expert says they need the documents, that's not good enough. You need the judge to say that.
Exactly. That's the difference between us, my lord. Of course I don't accept that, because my expert will say that their expert's wrong. And we need the judge to say who is right. And it's only at the point the judge decides who is right that I'm afraid you'll know whether there's been any conceivable prejudice to anybody. Save for the claimants if it's blocked out now. Those are all the submissions I wish to make. Unless I can help you, Lordships, further.
Thank you very much. Can I just ask...
Not a rejoinder, but just a point of fact. It was suggested that our position below was that the amendments should have been made by November 2022. All I'd suggest is that your Lordships look at what was actually said at paragraph 8 of our skeleton below, supplementary 34, page 388, and by Mr Richards in the transcript of the internal page 94, line 10, supplemental 30, page 327. It's just to see how we actually put it below.
Well, we were shown a paragraph in which you did say 29th of November.
We would say that it mischaracterises what the skeleton says, because the first sentence of paragraph 8 says that the amendments should have been pleaded at the outset, or at the very least, by ...
That's what that paragraph said.
And then what Mr Richards said in the hearing was that they should have been pleaded at the outset. Just.
Can I just ask the parties this? Judgment will be reserved. Our judgments will be reserved. It's now quite unlikely that you'll get judgment before the end of term, which means therefore it may not be until September, maybe even October. does that cause the parties concern with timetable?
My lords, our position is that we will have to accommodate it, because obviously what your lordships say will be important not only in the result but also in the reasoning.
I just point out to the court, and of course it's not your lordship's fault at all, that the expert reports are currently due on the present timetable on the 3rd of October. And so you can see the sorts of dilemmas that are going to arise. I appreciate that it's entirely a matter for the court. Obviously, an indication of the result might assist to know one way or another how to prepare for the next stage after the summer.
But the experts' reports will be after disclosure.
Yes, and
so your
disclosure's already happened, my lord.
yes, but there has to be further. If we find in a particular way, there'll have to be further disclosure.
There may, depending on what the outcome of a disclosure debate is.
You'll have to
Yes.
do an exercise.
Yes. Yes. As I understand it, there's some anticipation has been made in case that the appeal succeeds, or in case that steps have been taken to start the exercise of looking in wider places. But of course, we just don't know yet what the order will be on disclosure if the appeal were allowed. So anyway, that's the position we're in, and we completely understand that your lordships have expedited us this far. We'd be grateful for anything you can do, whether it's just an indication of outcome with reasons to follow at any stage before the end of term or not. We're in your lordship's hands.
Yes. Well, thank you for that. Do you want to add anything to that?
Well, no, just to observe that the timetable becomes very short given the fact that the experts reports are due from ENRC on the 3rd, I think, of October.
Yes.
And there's then a very carefully calibrated timetable for other experts thereafter. So I would just simply make the point that this is there.
Well, I understand that, and of course it's all been managed very carefully, I'm sure, by Mr Justice Waksman. My experience always was that parties would often end up compressing timetables as one got closer to trial. But we will. Well, I think all we can say is that we will do we're aware of the concerns, and we will do our best to get you the judgment as soon as we can. We'll consider whether or not we can give you an indication in advance. So, as I say, we'll reserve judgment, and we will circulate a draft in the usual way, in due course, and ask you to treat it with the usual care. You've given this to people to whom it can be circulated, and you know the strict rules about its circulation. If you can then provide us with any corrections, not an opportunity to re-argue, and it will be handed down in the usual way remotely. We'd ask you to seek to agree an order, and if there are any disputes as to it, if we could have written submissions, and we'll decide them on paper again in the usual way.
Lord, we are likely to ask for permission for the judgment to be also shown to certain supervisory bodies and officials within government.
I think I've already given you that permission.
I didn't know whether it had been addressed on the papers already.
Yes, I've already done it.
Very grateful.
Yes. So thank you all, and thank you to those behind you. We appreciate it. It's a team effort on all sides, and we're very grateful.
Court rise.